Good evening, everyone. I say good evening. Here in the UK, it's nearly midnight, so I wanted to do something a bit on the short side. I will still be doing a thorough read through of the decisions for each part that Judge Lyman ruled on. But I've highlighted a few areas that I just wanted to, because I've had a few questions. If her PR sexual harassment complaint has been dismissed, then, how is she still able to keep the PR retaliation claim in? So on and so forth. Some really great questions. So I've highlighted a few parts to this order, and I just wanted to have a quick chat about them. Hopefully this won't take too long, and there is one area of this order that you're not going to be happy with at all, and I can see Lively is going to be screaming at it. She is going to be citing it and just probably mischaracterizing it as well, but she's consistent. Okay, so this is the ALA, the Actalona Agreement. So the Actalona Agreement was deemed unenforceable. It is not enforceable, largely because it was never signed, as we all kind of anticipated, and that's that. There was also another reason. So here, her brief in opposition to the motion for summary judgment, however, fails entirely to respond to the Wayfarer Parties' arguments as to why Wayfarer should not be held liable under the agreements. This is on the basis that it was the Actalona Agreement was actually, the agreement was between It Ends With Us Movie LLC and Blakel Inc. She's trying to say that that basically, Wayfarer should also be liable, but Lively never really addressed that point. So Judge Lyman said, well, okay, you failed to respond to their point, and viewing the papers and circumstances as a whole, and the court deems her contract claims against Wayfarer abandoned. So that's why Wayfarer was out for that. Where it comes to It Ends With Us Movie LLC, we'll look at contract formation. Sorry, I'm just trying to get down to where this is such a big document. Oh, here we are. So the relevant part here is ultimately Lively fails to confront what is the central dilemma in her claim. She contends that the ALA became binding on It Ends With Us Movie at some point while the parties were still negotiating it, but she cannot pinpoint a time when the parties began to be bound by it, or which version of the Actalona Agreement they were bound to, because there was multiple versions. The existence of a contract requires a mutual assent and intent to be bound. Unless both parties are bound, neither party is bound. Which draft of the ALA bound Lively? Was it the version that lacked the sexual harassment provision? At oral argument, Lively's counsel suggested that the ALA became binding once the parties began performing under the agreement, which counsel stated was the beginning of filming in May 2023. But if that is so, it would mean that the ALA became binding before the sexual harassment provision was even proposed. And if it became binding at some later point, Lively cannot identify when exactly there was an agreement and what that agreement specified. The only conclusion that the undisputed facts would support is that the parties performed services pursuant to the offer letter. It is that document which Lively, through counsel, said that she would perform until such time that long form is fully executed. And it is only that document under which It Ends With Us Movie accepted her performance. In sum, the contract drafts, combined with the parties' other written communications and actions, conclusively establish It Ends With Us Movie's intent not to be bound to the ALA prior to its execution. Absent such intent, The ALA was never validly formed. Lively's contract claims under that agreement must therefore be rejected. So there you have it. That is why the ALA was considered unenforceable. Now, Lively also argued that Ainsworth's movie wavered their conditions precedent. Judge said no. No, they didn't. I won't go into that too much. I want to get to the contract rider agreement. All right, here he is. So Liman then went on to state that the contract rider is enforceable. And one of the questions I've had is, why is it enforceable if the ALA is not enforceable? Because Lively then tried to say that it was to be incorporated in the ALA. However, let's look. So Ainsworth's movie makes two primary arguments why Lively cannot enforce the CRA. It argues that the CRA was not binding because it made reference to the ALA and thus had no force prior to the ALA's adoption. Second, Ainsworth's movie argues that the CRA was not supported by consideration. Neither argument has merit. Okay. So I'm going to go down to here. And in what Judge Liman is basically saying, I'll just read it and explain a bit more. So regardless of where burdens in this case fall, there is sufficient evidence on the record to conclude that the CRA was supported by valid consideration. In particular, when the parties entered into the CRA, Lively's legal duty to return to set for the second half of production was at least doubtful or subject to an honest dispute. And I think this makes sense. I'm going to give just bear with. What he's saying is, the strikes paused everything. And when Lively come back to complete filming, that was on a different timeline. She may well, she could have, for all we know, she could have had another film booked in at that point, So actually, it wasn't her fault that the timelines changed. It wasn't Wayfarer's either, but that is the nature of the business, basically, is she agreed to 6 weeks of filming over a specified period. And due to the strikes, that period changed quite substantially as well, several months. So I'll keep going though. So the offer letter, the only agreement by which she was bound to perform, required her to provide exclusive principal photography services for up to 6 consecutive weeks. Right, and that's key. 6 consecutive, that's one after another. During the run of production. And filming paused 1 month into production due to the Writers Guild of America and SAG-AFTRA strikes. By its terms, the offer letter did not oblige Lively to commit to more than 6 consecutive weeks of principal photography. Her duty to continue with filming at that point on a different schedule than the one previously agreed to was therefore subject to at least some uncertainty. Her agreement to resolve that uncertainty by returning to set constituted valid consideration. That is what the CRA in fact recites. It states that the parties wish to confirm the conditions upon which Blakell has agreed to cause Lively to render acting services on the film following the break in production of the film related to the 2023 WGA and SAG-AFTRA labour strikes. The clear implication is that, absent agreement to the conditions, Blakell would not cause Lively to return to set. And because it was unclear whether Blakell had an obligation to cause Lively to return to set, and whether Lively herself had such an obligation, the CRA was supported by valid consideration and is binding. It ends with us movie also argues that the CRA is not enforceable because it makes reference to the ALA and the ALA was not executed. The argument has no greater merit. The CRA states that it shall be deemed incorporated into the ALA. The CRA also states that in the event of a conflict between the CRA and the ALA, the terms of the CRA govern. So what that basically means is, so Lively's work, she has worded it quite cleverly actually. So she basically said on the contract rider, that 17-point list of, extortion, as I call it, it says that this will be incorporated into the ACTA loan-out agreement. But if there is a dispute between a conflict between the 17-point list, the contract rider agreement, and the ACTA loan-out agreement, then the CRA, the 17-point list, governs, i.e., it takes precedence. So that basically nullifies Wayfarer's argument of, well, she referenced the ALA and the ALA wasn't executed, so therefore blah blah blah. No, that's not how Judge Liman is seeing it. And I can actually, now he's written that argument, I can actually see it and it makes sense. So that is why there's one agreement that has stayed and the other one has not. So yeah, at the bottom of that then, it ends with us movies. Motion for summary judgment with respect to Lively's contract claim under the CRA is denied. That means then that claim moves forward. Okay, her employment status. Okay. So I think when we had the Rule 56.1 statement, I went through it with a fine-tooth comb, and in many videos I said, well, hold on a minute, there's no way she's an employee. She had control over this, and this. Even the director, even Justin Baldoni's body double. She had control over everything, the script, the location, costume, hair design, the whole works, right? And I was like, that's not no employee's got that kind of freedom. That's just ridiculous. She was even able to approve a private plane to take her, if there was travel needed. So I called bullshit. And I was, not just myself, but a lot of us did. But it turns out we were right. So Judge Liman has cited a few examples here. Here, no change could be made to the script, the director, the co-lead, or the double, if any, for Lively without her permission. Lively had rights with respect to her hair and makeup. Because remember, her contract, it had that extensive list of everything she could approve, which was just wild. And then we had the unsealing, and the PGA letter was revealed, and all the things that, in her own words, Lively was telling the Producers Guild of America, I had control over this, and it was just even more extensive than her contract, right? And I knew that was going to screw her over. We all did. And sure enough, Judge Liman cites it quite a lot at this point. So the PGA letter indicates that she was shooting another film while simultaneously working a minimum of 10 hours a day on post-production for It Ends With Us. So she was already shooting another film while she was working on the post-production of It Ends With Us. She was shooting Another Simple Favor. So, analysis. The undisputed facts reveal that Lively enjoyed a degree of economic independence sufficient to make her an independent contractor. Although not every factor weighs equally in favor of that conclusion when viewed in isolation, analyzing the factors collectively eliminates any genuine dispute. That means Lively cannot bring a claim under Title VII. Okay? So, that's, she is, where are we? Yeah, there is more. Yeah, so effectively, she's an independent contractor. To my credit to Judge Liman, which I will give him at this stage because I won't be doing it later on, he goes further. In the PGA letter, Lively described Baldoni as not as an employer, boss, or superior, but as a partner in all creative and logistical concerns. It is undisputed that, among other things, she reviewed and reshaped the production and costume design for all key locations and characters, performed significant rewrites of the script to incorporate feedback from the cast, studio, distributor, author, director, reviewed and instated COVID-19 protocols, led meetings with all department heads, the studio and the distributor, oversaw a team of editors, and coordinated and managed cast and crew's various schedules for the film's press and release. Sorry, it jumped then. At any other point, I don't know why that is not staying. At any other point, she was free to accept additional work and to perform in other films, and she did so. The PGA letter indicates that she was shooting another film while working on post-production for the film. It ends with this movie. Stupid computer. Ends with this movie did not have a fixed location for shooting where Lively had to appear. It was All right, let's try that again now. Oh, it's so annoying. Sorry, guys. I genuinely don't know what's going on with this. Okay, we'll try it again. Sorry. It ends with this movie did not have a fixed location for shooting where Lively had to appear. It was a special purpose entity created only to produce the film. Lively herself led the location shift from Boston to New Jersey for principal photography. The remaining fact implicating the issue of control is that Lively, in her role as actor, was subject to direction by Baldoni as director. Now, I like what he's about to say. Any complex product will require the involvement of persons with different specialities. In the case of a movie, in addition to the director, it will involve actors, cameramen, lighting experts, sound experts, and the like. That each of them may to some extent be subject to the direction and coordination of the director does not ipso facto make each of them an employee. To hold that this sort of control determines Lively status would defy common sense, as it would result in classifying all actors as employees, regardless of the other aspects of the relationship, and that is the most common sense statement in this entire order. Lively may have been subject to some extent to Baldoni's direction. In the end, he was the one to call for lights, to direct the camera, to start shooting, and to tell the actors when to act. But his discretion was also not unlimited. Baldoni, too, was subject to constraints on his creative freedom. He was required to direct according to the script and did not have control over the script. And you're going to see this come full circle now, brilliantly, actually. For him to depart from the script, he needed Lively's assent. So she had control of the script, and Justin Baldoni had to direct in accordance with the script, but he was not free to do that because Lively had some control over the script. If, for example, Lively did not want a scene to deviate from the screenplay in a particular manner, he could not direct her to do so. And she managed to get the lift scene removed. Lively admits that she helped to block the staging of every scene for shooting efficiency. That after the labour strikes, she was writing as the film was shooting, and that she watched the monitor between every take to be sure that everything that ended upon the screen from every department was best service in the film and lead the changed need to get there when applicable. Okay. So far so good. So far, a lot of common sense. Apologies, I know some people don't love it when I'm scrolling, but it's a massive document and I've highlighted certain points. Okay, so California law. Okay. Again, a similar thing. Whether she was an independent contractor, etc., or not, he pretty much said the same thing. Well, hold on, she had all this control, etc. You know, if it ends with this movie, what to make any change to screenplay or to the director or co-lead for that matter, it needed Library's approval. So the same arguments here, and that is why summary judgment was granted for the California Labor Code claim. The extraterritoriality arguments from the motion for judgment on the pleadings. Is going to go into more detail. I'm not going to read everything because it's just too long, and I will do that in a separate video, but just for brief purposes here. So the court concludes that the California statutes do not apply to Lively sexual harassment claims, but they might to her retaliation claims. And we're going to see why. He does explain it. It makes sense. So he's ruled out California applying to the sexual harassment claims, or the sexual harassment claims are out anyway. This is very thorough. If nothing else, I'm starting to see now why it took so long to get that right. Okay, so I don't know if the highlight, if these have been highlighted. Basically, right, just to confirm that top paragraph there, which should be highlighted, but it's not. The court therefore grants judgment on counts 3 and 13 of the second amended complaint because those claims lack sufficient nexus to California. That means both Lively's federal and state claims. So that's the Title VII claims and the FEHA claims alleging sexual harassment fail to survive the Wayfarer Parties' motions for summary judgment and judgment on the pleadings. Now, don't just celebrate quite yet, because I will get to a point where he does make comments that you will not like. Okay. So now we're getting into, because I've had so many people say, hold on, how did FEHA retaliation survive if there is no FEHA sexual harassment? And it is a great question. So Judge Liman here says, before proceeding further, the court notes that the discussion below treats It Ends With This Movie and Wayfarer both as Lively's employer, not to suggest that there was an employer-employee relationship. There was not. He makes that very clear. There was not. But to conform to the language of the statute and case law, which use the term employer even in cases involving independent contractors. And that is a normal common thing where the statute uses specific language, but it's been interpreted over time in various cases to incorporate kind of other sub kind of headings of that thing. Then for the purposes of referring to the statute and complying with the statute, they will just use the language that is in the statute. But the courts, they will rely on case law, etc., where judgments have actually applied that statute to other, in this case, other types of employment status, such as independent contractor. Okay. So the first part of the test is establishing protected activity. Of course, a plaintiff's conduct may constitute protected activity, not only when the plaintiff opposes conduct that ultimately is determined to be unlawfully discriminatory under the FEHA, but also when the plaintiff opposes conduct that she reasonably and in good faith believes to be discriminatory, whether or not the challenged conduct is ultimately found to violate FEHA. So what is Judge Liman is ultimately saying is look, I've determined here that Lively does not meet he's dismissed her sexual harassment claims. I think it's fair to give you warning, right? He's dismissed them on the technicality that she is not an employee. She is an independent contractor, not because he believes that Wayfarer are completely innocent and, did nothing wrong. That is not the case. I've seen a lot of people say, oh, he's dismissed these claims because he thinks they're bullshit. He actually goes as far as to say the complete opposite. And that's what you're going to get annoyed about. However, he's dismissed the claims because she does not meet, the character category that they're intended to protect, i.e., she is not an employee. So they do not apply to her. But he's saying because she had a reasonable good faith basis to believe that the conduct was discriminatory, that is why the retaliation claims will stand. Now, we all know how we feel about how reasonable Blake Lively is. She's not. But at the end of the day, the law is the law and he has to apply the law. And what he's basically saying is, look, there's triable issues here. He's not ruling that she hasn't won. The ones that stay in does not mean she's won anything. It means that they're going to go to trial and a jury is going to be presented with the evidence and make a decision, unless they settle beforehand, which I can't see. And while I'm looking for the next bit, the reason I can't see it is because I think she'll see it through to trial. She'll claim that this is all a win on technicality, and she won't be right. She won't be wrong either. She will not be wrong. Tomorrow's headlines say Blake Lively loses all these claims on technicality. She will not actually be wrong. Because that is what's happened here. She's not an employee. That's the reason that Liman has thrown the SH claims out. If she was considered an employee, they may well have stood. I get the impression actually that they would have stood. But I think she's going to go to trial because I think she'll go to trial. She'll, probably lose. And then she'll want to appeal. That's the reason I don't think she'll settle. If you settle, you can't appeal. Okay. Where there is a triable issue of fact regarding whether retaliation played a substantial motivating role in the adverse employment action, a FEHA claim is not properly resolved on summary judgment. So Judge Liman is saying there are triable issues of fact. Here, the court finds triable issues of fact with respect to all three elements of Lively's FEHA retaliation claim. The first part of that is protected activity. So the protections letter, this is But yeah, the protections there, so that's 17-point list. Further provided that there shall be no retaliation of any kind against Blake Lively for raising concerns about the conduct described in this letter or for these requirements. Any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work, as a result of these requests is retaliatory and unacceptable and will be met with immediate action. So he's quoted point 17 from that contract rider. I think that is wildly broad and completely unfair, very subjective as well. I mean, who measures that? You know, who measures Justin Baldoni's happiness? Why can't Justin Baldoni have an off day and be happy? How it's got to connect to Lively as well. He can't just be in a bad mood on set and then Lively say, right, well, now you're retaliating. There's got to be a connection. Now, Judge Liman cannot make that decision. He has chosen not to. He's saying it's a triable issue. So this is what part of the reason why he's going to go to trial. And he goes on to say, and it required an all-hands meeting before returning to production to confirm and approve a plan for implementation of the above that will be adhered to for the physical and emotional safety of Lively, her employees, and all the cast and crew moving forward. And they had that meeting. The date of Lively's last instance of protected activity is relevant insofar as a short amount of time between such activity and an adverse employment action can raise an inference of causation. The court need not resolve this dispute. Lively's complaints made via the protections letter during the all-hands meeting satisfy the elements of protected activity, and, as further explained below, there is enough evidence that this activity was a substantial motivating factor in any adverse employment actions to survive summary judgment. Then we've got the good faith basis. To be sure, the Wayfarer Parties have suggested that Lively used her experience on set as a cudgel for control over the film. Heath stating that she continues to hold a threat over our heads, and every time we try to hold a line, she uses that threat either directly or indirectly to get us to fold. And then Baldoni stating that the protections were sent in an effort to gain power over him personally and the studio. And then Liman says, but a reasonable jury could find that Lively also genuinely experienced what happened on set as discriminatory. The two are not mutually exclusive. There is at least a triable issue with respect to whether Lively sincerely experienced what happened on set as sexually harassing. So there you go. That is why the FIHA retaliation claims are going to move forward, because at the end of the day, we all feel that Lively's talking shit. There's no evidence to support sexual harassment, and the sexual harassment claims have been thrown out anyway. But she may have had a genuine basis to believe retaliation because she genuinely believed she was sexually harassed. And that's what Liman is basically saying. So this is the part you're not going to like. This is on subject of objective basis. So, okay, I'll read the full thing actually. Viewed in the light most favourable to Lively, which has got to be done, there is also sufficient evidence that it was reasonable for her to believe that the Wayfarer Parties sexually harassed her by creating a hostile work environment. In analysing this issue, the court need not and does not determine whether the relevant conduct rose to the level of sexual harassment. The question is, instead, whether Lively's belief was, as some courts have put it, utterly baseless. And here's his opinion. There is enough evidence in the record to conclude that it was far from baseless. So, like what Liman is basically saying is well, her claims had merit. They were not baseless claims. He does go through the claims themselves kind of individually. He kind of poo-poos the idea of the fat shaming comment and so on and so forth, but he does kind of come down on Baldoni's comments about sexy and hot to Slate and Lively, and Heath's trailer thing. So yeah. Okay. Oh yeah, this footnote as well. Don't love this. Although Lively subsequently told Heath that she knew he was not trying to cop a look, one could reasonably understand that comment as an attempt to diffuse tensions with a producer on the film rather than a true reflection of Lively's understanding of the counter. So there we go. He's just responded. Lively hasn't made that argument, but he's making it for her. So in many ways, this is the motion to dismiss all over again. Okay. The court need not consider whether the acts, as alleged, would support a jury verdict that the Wayfarer Parties created a hostile work environment under FIHA. It is sufficient that it was reasonable for Lively to believe that they did. Noting that even if a plaintiff's beliefs regarding sexual harassment are legally mistaken under FIHA, a retaliation claim might be sustained where the nature of the complaint reasonably falls within the statute's general purview. I don't think there was anything else. Oh, actually, there might have been. I mean, he threw out the false light because, New York does not recognize false light. Oh, I knew there was something else. Right, okay. This is the aiding and abetting. So the other question I've had is, well, why was Nathan and Abel? Why were the claims against them for this particular cause of action? Why were they kicked out, but they remain against TAG? So the simple reason for that is because they are individuals, and there is no aiding and abetting liability for individuals who are non-employers. That's actually what he says. Accordingly, there can be no aiding and abetting liability for individual non-employers on a theory of either discrimination or retaliation, where the individual is acting as an agent for the employer. Aiding and abetting liability instead applies to third parties, such as customers or suppliers who induce or coerce conduct prohibited under FIHA. The parties have not addressed this issue at any length. They have instead treated the aiding and abetting defendants without differentiation. The court therefore withholds judgment with respect to whether TAG might be liable for aiding and abetting via retaliation. Because Nathan and Abel cannot be held personally liable for aiding and abetting retaliation, judgment must be granted in their favour. And again, that's just because they're individuals. The motion for summary judgment with respect to TAG is denied without prejudice. So basically, TAG is an organization, basically. And they got to meet certain conditions. It can't just be an organization. I think they've got to have at least 5 employees and basically enforce FIHA standards, etc., etc. Yes, the false light was thrown out because it's not recognized in New York. Defamation. This is largely against Friedman's statements. And judge basically says, look, he was kind of mirroring what his own clients were saying in their complaint. So it's not defamation. Yeah. Okay. Yes, and they were both framed in terms of the issues raised in court and consistent with the Wayfarer Parties' in-court positions. Any ordinary viewer or reader would therefore understand that Friedman was commenting on a judicial proceeding. So, because it was already, what the same thing basically that Wayfarer put in their, in their complaint in a judicial proceeding, then Friedman was commenting on that, and any reasonable ordinary viewer or reader, which Lively is not, would understand that that's what he was doing. We all said that. So, Wayfarer Parties got summary judgment on the defamation claim, so that's out. Conspiracy was there can be no. Yeah, so the court has granted judgment on Title VII California Labor Code false light and defamation claims. Accordingly, there can be no conspiracy liability for these claims, and the Wayfarer Parties are entitled to summary judgment on the claim of civil conspiracy to violate these laws or commit these torts, because the conspiracy is on basically those predominantly those laws, and if they're out, well, there's no conspiracy. Regardless of whether he also says, because obviously the retaliation under PHAT is still in play, so Wayfarer Parties are also entitled to summary judgment on the claim of conspiracy to commit retaliation under PHAT, regardless of whether New York's or California's law of conspiracy governs. Lively cannot accomplish by way of civil conspiracy what she is unable to do under PHAT itself. PHAT permits aiding and abetting claims under certain circumstances, but it also places specific limitations on that form of liability. Lively cites no authority, and the court has found none permitting a party to evade the carefully drawn limitations on aiding and abetting under PHAT by the artifice of pleading the claim in conspiracy. In fact, the courts have recognized just the opposite. So, but she cannot use conspiracy. He also says, accordingly, a civil conspiracy claim which exceeds the scope of PHAT's aiding and abetting provision cannot be brought. So there we go. Motions for judgment on the pleadings and summary judgment are granted in part, denied in part. Judgment is granted on the Wayfarer Party in the Wayfarer Party's favour with respect to all counts in the second amended complaint, except for 1. Lively's fourth cause of action for retaliation in violation of PHAT against It Ends With Us movie and Wayfarer. 2. Lively's seventh cause of action against TAG for aiding and abetting retaliation in violation of PHAT. And 3. Lively's ninth cause of action for breach of the contract rider agreement against It Ends With Us. So there are only 3 causes of action remaining, 10 are gone. So, yeah. Like I say, technically it is a win. But it is not a win because, Judge Liman is saying, well, actually, Lively did bring a claim for sexual harassment with merit. And I don't like that. I also don't like that he's making excuses. Well, he's offering up, what Lively probably meant when she said to Jamie Heath, oh, I know you weren't trying to cop a look. I don't love that. But we have 3 causes of action, which are going to go to trial. So we'll just have to, we'll see what happens there. We'll see what happens next. Oh, the hearing wasn't much either. Basically, oh gosh, the audio was awful, absolutely awful. But all that happened in that, it was only going for like a few minutes, literally. Judge Lyman basically turned to Wayfarer's lawyer, Jonathan Back, and said, "You asked for this, this hearing. Do you want to, say what you want?" And Back responded with, "Well, it's kind of mute now because of the order." And he's said to Judge Lyman that we'll just go and meet and confer with Lively's law and discuss the pretrial motions because now they've got a hell of a lot less work to do. And Judge Lyman basically finished up by saying, "Okay, let me know if there's any change to the length of time needed for trial," and that was it. There was nothing exciting at all. It was incredibly hard to hear. But yeah. So there we go. We're all caught up. I will do a longer read through because the points in that order are it's so detailed and it's really, really interesting, but it's just a lot to get through. So I wanted to do something a bit shorter to get to the basic points and answer some of the questions that I'm already getting, because I completely see why people are like, oh, sexual harassment's gone, but retaliation's still. I get it. But the order does explain it quite well, so it's just finding those points. But like I say, there's some stuff in the order I don't love either. All right, guys, have a good evening and a great Easter as well. If I'm not able to come back tomorrow to do the longer video.